Mike Brown, the former FEMA director.
Joining us here is the former FEMA director.
History, I think, was very unkind to you, my friend. Very unkind.
Mr. Brown, thanks for being with us.
This is Michael Brown Unplugged.
Executive privilege is in the news, and I wanted to talk about it a little bit because you're going to hear all sorts of misinformation about what executive privilege is, why it's being invoked, and probably the most telling thing that you're going to hear about executive privilege is that President Trump is using it because he does not want information that he discussed with his White House counsel or other White House officials to get out into the news. The reason this has come about is because the House Judiciary Committee has issued a subpoena to Don McGahn, who is the former White House counsel. McGahn, because he's been issued a subpoena, has an obligation, a legal obligation, to appear before Congress and testify, answer the questions that members of the House Judiciary Committee might have regarding Russian collusion, regarding any sort of conversations between the counsel, Don McGahn, and the president about whether or not, try to getting him to fire the special counsel, about whether or not certain people should testify or not. That's the big issue. In a nutshell, it is this. The former White House counsel, Don McGahn, is issued a subpoena by the House Judiciary Committee. That imposes upon him a legal obligation to testify before the House Judiciary Committee, but the President of the United States, going all the way back to George Washington, has what is called executive privilege. And you also have the issue of lawyer-client privilege, because Don McGahn was the White House counsel. So the White House, not the president, but the White House has an interest in protecting the attorney-client privilege between the counsel that advised the White House. And when I say the White House, I mean the chief of staff, the communications director, the legislative director, all of the people that work in the White House. Now, I have a particular interest in this because I was faced with a similar situation. And before I tell you and describe to you why executive privilege is important, let me tell you about the experience that I had. So after Hurricane Katrina, the House and the Senate both wanted me to testify about what took place. And in particular, because just as they're trying to politicize this whole Mueller report, at the time, back in 2005, 2006, Democrats were trying to politicize Hurricane Katrina. So their idea of politicizing it was to somehow get me, as the Undersecretary of Homeland Security and the Director of FEMA, to testify in front of the Senate Homeland Security Committee. At that time, I believe it was chaired by Susan Collins, the senior Republican senator from the state of Maine. Their idea was to get me to testify about conversations that I had had with President Bush about how bad Katrina was going to be, because there was a lot of controversy about whether or not, one, we were prepared for it, two, what our reaction to it was. And as you may recall, the president did that flyover where he just looked down on New Orleans and didn't actually land in Baton Rouge like I had asked him to do, so that we could kind of garner the strength of the entire cabinet to help me respond to that disaster. So the idea was very simple. Let's get Michael Brown to testify about his conversations with President Bush. Now, I had already voluntarily appeared for depositions. I had voluntarily appeared in front of the House committees. We had testified for hours upon hours about everything that took place. So after one of those hearings, I'm walking out of the building and somebody taps me on the shoulder, and I turn around, and there's what looks to be a 20-something staffer who says, "Mr. Secretary," and hands me a subpoena. And I just chuckled, and I looked at the kid, and I said, "Seriously? We've already agreed to testify. We're going to be there." But the purpose of the subpoena was to impose upon me as an individual, just as a private citizen, because I was no longer the undersecretary at that time. The whole idea of the subpoena was to impose upon me a legal obligation to appear before the Senate committee and answer their questions. So, of course, my lawyer reaches out to the lawyers for the Senate, the Senate Homeland Security Committee to start talking about, well, what kind of questions are you going to ask? What are you going to be asking about? What's the subject matter of what you're going to ask? Because we wanted to be prepared. And in the course of those conversations, it became readily apparent to us that what was happening was they wanted me to testify about private conversations I had had with President Bush about everything going on behind the scenes in Hurricane Katrina. So that set up a battle between me being under a subpoena to testify and the White House being able to assert their executive privilege to prevent me from testifying. Now, executive privilege belongs to the president. And the president is the one, the White House in general, the president is the one that can invoke executive privilege. It's their choice. I don't get to do it because I'm not a member of the executive branch. Congress doesn't get to do it because they're a separate but equal branch of government. Executive privilege belongs solely to the White House. So this led to a conflict. I have to appear because I'm under a subpoena, but I can't testify if, and it's a big if the White House imposes executive or asserts executive privilege. So here was the game that we played. And then I'll get back to what is happening in the Mueller case with the current White House counsel. The game we played was this. I would agree to appear in front of the Senate committee. Either Senator Lieberman or Senator Collins, I forget which one, would then ask me a very specific question about my conversation between President Bush and me about a particular subject matter on a particular date. And then we would wait. We would wait in the hearing room, and the chair, Senator Collins, and both Senator Lieberman, would then ask, is there anybody from the White House here today who wants to assert executive privilege and not have Mr. Brown testify with regard to the question that was just asked? Because it was a very specific question about a conversation between me and President Bush. So they make that announcement, and they wait, and there's silence. And there's actually kind of a joke made because I think Senator Lieberman said, well, I'm going to assume that there are people from the White House that are in the room today, but no one is asserting executive privilege. He waits a couple of more seconds and then directs me to answer the question. And I answer the question because the White House did not assert executive privilege. So now I'm free to testify about my conversations, the private conversations between me and President Bush. That is what has happened to Don McGahn, the former White House counsel. Now, the White House plans to fight the subpoena issued by the House Judiciary Committee for Don McGahn, and the Trump administration also plans to oppose other requests from the House committees for the testimony of both current and former aides about actions in the White House described in the special counsel's report, according to people that are familiar with what's going on inside the White House. White House lawyers plan to tell attorneys for administration witnesses that are called by the House Judiciary Committee that they will be asserting executive privilege over their testimony. If they do that, that sets up a move that will intensify a power struggle between the Trump administration and congressional Democrats, potentially, and I think likely, setting up a protracted court battle. Now, McGahn, the White House counsel, was mentioned more than 150 times in the Mueller report, and he told investigators, the Mueller investigators, about how the president was pressuring him to oust the special counsel and then pushed him to publicly deny the episode. McGahn's lawyers have already started having discussions with the Judiciary Committee about his potential testimony after the panel issued a subpoena to him on Monday. Now, securing the White House counsel's testimony would be an absolute boon for the committee because they want to focus on potential obstruction of justice by Trump in a series of public hearings this spring while exploring other abuses of power. So here's the battle that's set up. The White House counsel gets the subpoena. The White House counsel, I should emphasize the former White House counsel, because this is exactly the same position that I was in. Don McGahn, just like me, was a former White House official. So Don McGahn, former White House counsel, Michael Brown, former Undersecretary of Homeland Security. We both get subpoenas. We're both ordered by that subpoena, and we have a legal obligation to appear before the committees, and we have a legal obligation to testify. But if the White House asserts executive privilege, then Don McGahn cannot answer the questions about his conversations with the president. In my situation, the White House did not appear, did not assert executive privilege, and so I was free to then go ahead and testify. Now, you're going to hear a lot of misinformation about executive privilege. You're going to hear things like the president's trying to cover up stuff. The president's trying to prevent things from happening. The president's trying to keep Congress from finding out what he said to his counsel, what he said to the White House lawyer. And it's going to be framed in such a way that those who just kind of, consume their news without really thinking about it are going to believe that here's a situation where the president is trying to hide something. Let me disavow you of that. The president indeed may be trying to hide something. There may be things that Don McGahn, the former White House counsel, would testify that would put the president in a, let's just say, a not very good a very good light. It may make the president look bad. But setting all of that aside, let me make the argument for why executive privilege is important. Now, just as a historical point, executive privilege has been asserted by, I think, virtually every president of the United States. George Washington asserted it. He set the precedent for executive privilege. There was a failed military operation against Native Americans, and Congress wanted to know what happened. They wanted records and testimony from White House officials. But President Washington and his cabinet agreed that a president had the right to refuse these requests in the name of national security. But Washington also argued that the House of Representatives had no right to see the discussions that took place internally about whether or not this military operation was going to take place, what happened, why it happened. Here's why it's important. I know that you have discussions in your office with, okay, we're going to roll out a product. We're going to roll out a service. So you have all of these internal discussions about marketing options, about problems with the product, about how you're going to get that product or service marketed in such a way that you're going to succeed in the rollout. All of those discussions are discussions that you do not want to ever become public because everybody needs to be free to have the conversation. Everybody needs to be free to talk about the service or the product. It's good points, it's bad points. And the same is true with executive privilege. The President of the United States, the executive branch, needs to have the ability to have open and honest conversations about policy decisions, about positions you're going to take on legislation, about things that you are going to do or not do in terms of executing the laws that Congress passes. If you cannot have those open and honest discussions because you fear that everything that you say will become a public record, that has a chilling effect on those discussions. We should want the White House, we should want the executive branch to be able to have free and open conversations about what are we going to do? How are we going to do it? Why are we going to do it? And people in those rooms, in those just imagine, you're in the Roosevelt room of the White House. The president is sitting there. There's a particular issue in front of you. I think about this on 9/11. After 9/11, we sat in the Roosevelt room and we had very serious, open discussions about what we should be doing, why we should be doing it, how we should be doing it. And we had, people would say, we can't do that. We should be doing this. It was this free and open conversation. At the end of those conversations, you reach a decision. Now, once that decision is made, that decision becomes public. But everything leading up to that discussion or that decision should be protected by executive privilege, just as President Washington wanted to protect his discussions with his generals. He wanted to protect the discussions with his staff about why we should or should not do something, because you always want the ability of your staff to be able to tell you the truth and speak openly about what you're contemplating doing. If you're the CEO of a company, you want all of your staff to be able to openly and honestly discuss with you what you're thinking about doing. And the same is true with executive privilege. Now, having said all of that, if the president wants to, he can waive executive privilege and he can tell his White House counsel, go testify. I have nothing to hide. I'm tired of this. I want all of this out in the open. And if it makes me look bad, it makes me look bad. The same was true with President Bush. The things that I had to say to the Senate Homeland Security Committee actually made President Bush look like he was not really paying attention. But the president waived executive privilege, and I was able to tell the truth about those conversations. So that's the battle that's been set up, and you're going to hear about that in the news. And what I want you to understand is that executive privilege is a right that the White House and the president has to protect those internal discussions. Whether or not the president waives executive privilege is up to him. It's not up to Congress. It's up to him. Now, if he invokes executive privilege, mark my words, this will eventually end up in the Supreme Court. It will go to a federal district court. It may go directly to the Supreme Court. I don't know how it will happen, but this will be litigated. And the court will have to decide, once again, whether or not what the president is doing in asserting executive privilege is constitutional and whether or not he has the right to do it. There is a long line of precedent. Washington did it. Eisenhower did it during the McCarthy Crusade. Nixon did it, obviously, during Watergate. Bill Clinton did it. Barack Obama did it. George Bush did it. Every president that I can think of has at one time or another invoked executive privilege. So when you hear about it in the news, you're going to understand what it is, why it exists, and that it is the decision of the president to do it. Pay attention. We'll see what happens. As long as we're talking about legal stuff, maybe it's time for another Michael Brown constitutional law class. So get out your Big Chief tablets, get out your crayons. Let's talk about a case called Taylor versus City of Saginaw. I am fascinated by this case. It comes out of the Sixth Circuit, and it has to do with chalking a tire to see if the car has been moved. You know how meter maids, and I find the word meter maid kind of funny because isn't that kind of sexist? Because I don't know whether this meter maid, I think the meter maid in this case actually was a woman. But if it's a man, do you call a man a meter maid? I don't know. Just a sidebar that I find kind of funny. But you know the practice. So instead of having a parking meter, there will be the signs that say, between this sign and that sign along this block, it is 2-hour parking. And so what the meter maids do to ensure that you don't pass your 2-hour parking, they walk by, they see a car parked, and they have this long stick that has a piece of chalk on the end of it, and they mark your tire. And the whole purpose of that is to then walk around, and they come back 2 hours later, and if that car is still parked in the same place, they still see the chalk mark. You've now exceeded the 2-hour limit, and they give you a ticket. It's called chalking. Now, I'm not sure that the decision is correct, but I do think it's plausible on current law, and it really raises some, I think, fascinating issues. So let's start with the facts of the case, because I think, well, that's what we should always do, because the facts of the case are what the court uses to apply the law. So here are the facts. This woman named Allison Taylor, she gets a lot of parking tickets, and she decided to make a federal case out of it. She sued the city of Saginaw in federal court, and in her lawsuit, she alleges that her constitutional rights were violated by this practice of chalking her tire to figure out whether or not she had overstayed the time that she was permitted to park her car in that particular spot. Now, I don't know. I did a quick LexisNexis search, and I can't find any other cases in which chalking was alleged to violate the Fourth Amendment. But the Sixth Circuit ruled that this practice of chalking a tire violates the Fourth Amendment. So, what do? Just as we always did on radio, let's pull out our pocket Constitution. Amendment 4. Amendment 4, the Fourth Amendment, says this: the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. Now it goes on to talk about warrants, but this is the pertinent part. You have the right to be secure in your persons, houses, papers, and effects against unreasonable searches. Now, here's what the court, here's their reasoning. The court said that chalking is a search of the car. Now, why do you think it's a search of the car? Because this is where I think the court might be wrong, but personally, while legally I think it's wrong, I love this case because the court is taking a plain meaning reading of the Fourth Amendment and saying this is a violation of the Fourth Amendment. Here's the reasoning. They say that chalking is a search of the car because it is a trespass onto the car to obtain information. Now, there's a case called United States versus Jones. It's a trespass under this case because it satisfies the common law trespass case. Here's what the court said. In accordance with Jones, the threshold question is whether chalking constitutes common law trespass upon a constitutionally protected area. Stop. Let's just stop for a minute. All right, the threshold question. Does this practice of chalking constitute a trespass, and is that trespass against a constitutionally protected area? Well, a plain reading of the Constitution would be yes. It is a trespass. You have reached in and you have trespassed upon my personal effects, my car, and you have marked it. Now, it may be that chalk doesn't harm anything. The chalk doesn't hurt the tire, but nonetheless, it's like an assault and battery. If I touch you and you don't want me to touch you, that's an unwanted touching and could be considered a battery under plain meaning, plain reading of the statute. So under this case of United States versus Jones, it is a trespass. Then you have to ask, is it a trespass upon a constitutionally protected area? Well, yes. Your car is a constitutionally protected area. How do we know that? We know that because there's a lot of case law that says that if you want to search my car, you have to have probable cause. You first have to, you have to have a reasonable suspicion to pull me over, a reasonable suspicion that I'm speeding or something. But just speeding, pulling me over for speeding, does not give you probable cause to search the car. There has to be something else. You have to see contraband. You have to see something suspicious in the car that gives you probable cause to search it. And then you have to get a warrant to do so. So the car, as we've always, I I'd have to go back and research the cases, but the car itself is a constitutionally protected area. You wouldn't want someone searching your car without probable cause or without a warrant. Now, the court goes on to say this. Though the Jones case does not provide clear boundaries for the meaning of common law trespass, the restatement of the law offers us some assistance. As defined by the restatement, common law trespass is, quote, an act which brings about intended physical contact with a chattel. That would just be something that you own. A trespass is an act which brings about intended physical contact with a chattel in the possession of another. Moreover, the court says, an actor may commit a trespass by so acting upon a chattel as intentionally to cause it to come in contact with some other object. That is the definition of a trespass. So if you're marking the car with chalk, that is a trespass. And if that trespass is upon a constitutionally protected area, which is the car, which we know is constitutionally protected, now you have a constitutional violation. The court said, as the district court properly found, this physical intrusion, regardless of how slight, constitutes common law trespass. This is so, the court says, even though no damage is done at all. Isn't this fascinating? Because if we truly got back, as I have argued for decades, if we truly got back to just the plain meaning of the Constitution, all of these rules and regulations that we have that we just accept without any question would be tossed on their head and thrown out. So now the court has to ask the question, is it an act conducted to obtain information? Because if you are conducting a Fourth Amendment search, what are you trying to do? You're trying to obtain information. So there's a murder. You have a suspect. You get a warrant to search that suspect's apartment or house. What are you trying to do? You're trying to find information. What is the meter maid doing? When she conducted that trespass by marking the car, she is what? She's trying to find information. Shouldn't that information be subject to a Fourth Amendment warrant? Here's what the court wrote. Once we determine the government has trespassed upon a constitutionally protected area, we must then determine whether the trespass was conjoined with an attempt to find something or to obtain information. Here it was. Neither party disputes that the city uses the chalk marks for the purpose of identifying vehicles that have been parked in the same location for a certain period of time. That information is then used by the city to issue citations. As the district court aptly noted, despite the low-tech nature of the investigative technique, the chalk marks clearly provided information to Hoskins, who was the meter maid. This practice, the court says, amounts to an attempt to obtain information. It's a Fourth Amendment violation. So they concluded that the chalking was a search, and they then concluded that it was unreasonable and that it was therefore unconstitutional. The basic idea here is that no exceptions to the warrant requirement apply, so by default, the warrantless search is unlawful. Fascinating case. Now, will this go to the Supreme Court? I don't know. The fact that it's gone from a federal district court all the way to the Sixth Circuit Court of Appeals means that, it could. It could end up going to the U.S. Supreme Court. So every time that you now park and the meter maid chalks your car to see how long you've parked, I want you to think about this case. Because this is where I say, if we would go back, and I would encourage you to do it. Those of you who have listened to me for years know, how many times have I told you? How many times have I really urged you? Get online, find the text of the U.S. Constitution, and just read it. And if you just read it and you just think about the words on the paper, the plain meaning of the words, you would see that in so many ways, this country has veered so far away from the plain meaning of the words that the founders would be spinning in their grave. And I know this is a simple parking violation, but if you apply the Fourth Amendment to a simple parking violation, you will see that in many cases we have just allowed government to just expand and intrude into our lives in such a way that is totally unreasonable. Now, let's talk about the parking situation. What if, instead of chalking the car, there were meters, so that you put the money in the meter, you get to park there for an hour and 15 minutes. You leave after 30 minutes, meaning that there is still, let's see, an hour and 15 minutes, so that's, I'm trying to do the calculation, that's 75 minutes. You park there for 30 minutes. There's 45 minutes left on the meter. You pull out, go on about your business. I'm right behind you. I pull into the parking space. The meter still shows that there's 45 minutes. Am I entitled to park there? Yeah. Because even though I didn't pay for it, somebody paid for it, and there's still 45 minutes of parking time on that meter. Now, if I stay longer than the 45 minutes, I stay 60 minutes, and so now the meter shows that it is expired, and the meter maid comes by and sees the expired meter, gives me a ticket. I think that's purely constitutional. Why? She didn't touch my car. She didn't obtain information from my car, which is a constitutionally protected chattel, object, car. She just saw my car's parked there. There's no time on the meter. I get a citation. So the chalking is a trespass and a violation of the Fourth Amendment. The meter wouldn't be, because there is no investigation. There is no chalking. There is no information obtained from my constitutionally protected vehicle. Fascinating case. And I hope I hope it spurs you to go online. Just plug into your search bar text of U.S. Constitution, and then just read it. Just read it. And I think you'll understand just how overly intrusive the government has become. We'll keep track of this case, Taylor versus City of Saginaw, and see whether it goes to the U.S. Supreme Court or not, and I'll let you know. There's been a lot of news recently about felons being able to vote, and I wanted to talk about that topic for just a few minutes, because it's actually a pretty simple topic in my mind. If you're a convicted felon, now this all started with Bernie Sanders. Well, in fact, let me go to the tape, as they say. Kamala Harris was asked at a town hall about whether or not felons should be allowed to vote, and in the course of her discussion with the CNN moderator, they talked about Bernie Sanders' proposal.
He is in favor of felons being able to vote while serving in prison. He was asked specifically about people like the Boston Marathon bomber, also people who are convicted of sexual assault. And he said, this is a quote, "The right to vote is inherent to our democracy, yes, even for terrible people." Do you agree with that, Senator?
Now, it's a simple question. Do you agree that the Boston bomber should be allowed to vote in, he was in Massachusetts, although he's actually, I think, now down in Supermax here in Colorado, the big prison in Colorado. But the question is, should the Boston bomber be allowed to vote? Well, my answer to that is a very simple no. He's still a felon. He is still serving his sentence. If he had served his sentence, if he had been released, completed his probation, done whatever he was supposed to do to pay back his debt to society for the crimes that he committed, then I think those voting rights should be restored. But if you are a murderer, like the Boston bomber, and you are sentenced to life in prison, there is no way that you can earn back that ability to vote. So I think it's a pretty simple question and answer. If you're a convicted felon, you're still in prison until you have served your time, until you have done everything that the court requires under your sentencing, served your time, done your probation, paid your restitution if any restitution is required, paid the fines, whatever. Once you have done all of those things, even though you remain a convicted felon, I think you have paid your debt to society, and you should then be able to vote. Kamala Harris, in response to Bernie Sanders' statement that the Boston bomber should be able to vote, had this disingenuous response.
I agree that the right to vote is one of the very important components of citizenship, and it is something that people should not be stripped of needlessly, which is why I have been long an advocate of making sure that the formerly incarcerated are not denied a right to vote, which is
Now, I agree with that the formerly incarcerated, if you've done everything, should have your voting rights restored. But she has yet to answer the question about the Boston bomber.
the case in so many states in our country, in some states permanently deprived of the right to vote. And these are policies that go back to Jim Crow. These are policies that go back to the heart of policies that have been about disenfranchisement, policies that continue until today.
I'm not going to argue about Jim Crow. I'm not going to argue about disenfranchisement. I think she's doing that because she's playing to her base. But remember, we are now 55 seconds into this clip, and she still hasn't responded to the question about the Boston bomber.
And we need to take it seriously.
But people who are convicted in prison, like the Boston Marathon bomber, on death row, people who are convicted of sexual assault, they should be able to vote?
I think we should have that conversation.
I think we should have that conversation. If you commit a crime, a heinous crime, for which you are sentenced to life in prison with no possibility of parole, you have lost your right to vote. And barring some unforeseen circumstances that would have you released from prison and have that counted as serving your sentence, then I think you could apply to have your voting rights restored. But as long as you are in prison, as long as you have not completed all of the terms of your sentencing, I don't think you should vote. I don't think people who are sitting in prison doing their time should vote, but only those who have served their time, paid their price to society, been released, then you get the right to vote. Why is this an issue? Why would it be that Bernie Sanders and Kamala Harris and everybody else want that those Democrats want felons to get the right to vote? It's another constituency class. Just as they go after illegal aliens and want illegal aliens to be able to vote, people who are not even citizens of this country, the same is true with those who are incarcerated. They want those who are incarcerated to vote. Why? Because they think they can get those people to vote Democrat. And by bringing the issue up, unless we learn to capture this issue for ourselves and say, yes, just as I did, I think my position is pretty reasonable. If you're a convicted felon, you're still serving your prison time, you should not have the right to vote. On the other hand, if you have paid your debt to society, even though you are technically still a convicted felon, I think your right to vote should be restored. So pay attention to this, because I think this is a political issue that they're just trying to set up for the 2020 presidential campaign. Some of you may or may not be aware that a woman in Boulder has paid to have 3 billboards. Wasn't there a movie? 3 billboards in some place, I forget. Frances Dorman, I think, was the actress, and it was about trying to find the truth about the killing or accident of her son, and she put these 3 billboards up outside of town. Well, this woman in Boulder, Colorado, has put up 3 billboards in the Denver area. And here's what the billboards say. More Americans have died of gun violence since 1970, including murders, suicides, and accidents, parentheses, 1.4 million, than in all the wars in American history, parentheses, 1.3 million. Thoughts and prayers are not enough. Now, these billboards have become news stories on both local and national TV news programs. The only problem? The billboard is a lie. The message is a lie. Why is it a lie? All you have to do is look at the definition of the word violence. Here's what the Oxford Dictionary says. Violence, behavior involving physical force intended to hurt, damage, or kill someone or something. Now, notice the inclusion of the word intent in the definition and the absence of the words or one's self as the target of violence. We don't refer to the 30,000 per year who commit suicide because of intentional drug overdoses as, quote, victims of pill violence. Nor do we refer to those who kill themselves by slitting their wrists as, quote, victims of razor blade violence. So that begs the question, why do all of these anti-gun people inappropriately and inaccurately use the word violence in connection with suicide by a gun? But let's go on to accidental gun deaths. Note the inclusion of the word intent in the definition of violence. By definition, if a person is killed accidentally by a gun, there was no intent. Therefore, that person was not the victim of violence, gun or otherwise. Oh, and how about people justifiably killed by the popo in the course of committing a crime? That happens about 1,000 times per year. Are they victims of gun violence? No. They are not victims of gun violence in the sense of what this woman's trying to say. Remember, here's what the billboard says. I want to remind you, listen closely. More Americans have died of gun violence since 1970, including murders, suicide, and accidents, 1.4 million, than in all the wars in American history, 1.3 million. Thoughts and prayers are not enough. If this woman is the stereotypical anti-gunner who refuses to deal with facts. Let's break down the numbers on the billboard. Every year, about 2/3 of all gun deaths are suicides. That would account for about 800,000 of the 1.4 million figure on the billboard. Accidental gun deaths have also averaged roughly 500 per year, which would account for another 24,000 deaths from gunshot wounds over the past 48 years. That's the period she cites on the billboard, 1970 to 2018. Justifiable police homicide would account for another 48,000. So if you subtract those gun-related deaths from the 1.4 million claim, that would yield just 528,000 people over a 48-year period who were actual victims of gun violence, or, to put it another way, about 11,000 per year. That figure is very close to the reported figure by the FBI in their annual Uniform Crime Report, and a number, listen closely, a number that has been declining by almost 40% since it peaked at more than 19,000 in 1993, despite more than doubling the number of guns in this country during the same 25-year period. So this woman, putting these billboards up, is perpetrating a lie. The number of guns in this country has been increasing exponentially, but the number of people that are killed directly by gun violence, and let's think about that, gun violence. I decide to go kill somebody with one of my guns. That's gun violence. But it is not gun violence if it is suicide, if it is killing by a cop, justifiably, or it is an accidental death. She's trying to take the word gun violence and then dump into that bucket defined as gun violence all of these other situations that truly are not gun violence. Now, finally, this billboard says that thoughts and prayers are not enough. That implies that no gun control legislation has been passed in this country in the past 48 years. Is the person paying for the billboards oblivious to the mountain of gun control legislation that has been enacted in this country at city, state, and federal level since 1970? Is she not aware of the numerous states that have adopted universal background check laws, enacted those red flag gun seizure laws, the federal ban on bump stocks, the 1986 federal ban on the sale of armor-piercing ammunition, the numerous local magazine capacity limit laws, the assault weapon ban laws, the use of computers to collect data on people not allowed to buy or own guns, and the use of those same computers to run enhanced background checks at the time of gun purchase? Is she oblivious to all of those laws that have been enacted in lieu of thoughts and prayers over the past 48 years? This drives me nuts. And it drives me nuts because we have an individual right under the Second Amendment to, let me pull it out again. I'm right back to the same practices. A well-regulated militia, that's you and me, being necessary to the security of a free state. The right of the people to keep and bear arms shall not be infringed. Why is it? Why is it that we are so focused on guns when guns are not even near the leading cause of death in this country? And the use and possession of guns is a constitutionally protected right. When you divide the number of people murdered by a gun in this country in 2017, 10,982 people. That's the last year for which there's FBI data available. When you divide that number, 10,982, by the estimated 320 million guns in this country, you come up with the percentage of those guns that were used to murder anybody last in that year, 2017, 0.03%. That means that the other 99.97% of the guns in this country were not used to murder anybody in 2017. I do not know of any other government program or government-regulated product or government-regulated process that has that kind of success rate. 99.97% of the guns in this country are never used to murder anybody else. I would like to know exactly what new constitutional laws this crazy woman who paid for the billboards would like to see enacted that would materially reduce that 0.03% rate. This is the insanity of the gun debate in this country. I don't know why. There's a part of me that says that the focus on guns is out of ignorance. But the other part of my brain says the focus on guns is people who are using the useful idiots to try to obliterate the Second Amendment, to take away our right of self-defense, and to take away our right to protect ourselves against a tyrannical government. And every time somebody says, "Oh, Michael, that is a crazy-ass attitude because we don't need guns to protect ourselves from a tyrannical government." Seriously. Do we have any examples, any real-life, current-world examples where a tyrannical government is imposing its tyranny on the people because the people are unarmed? Oh, we don't have to look more than 90 miles from the shores of the United States of America to see the closest example of that, Cuba. or Venezuela, or now even democratic parliamentarian governments like Australia, or now New Zealand. When you start taking away the right of the people to defend themselves against a tyrannical government, that empowers governments to become even more tyrannical. And I know people who think that that is crazy talk because, well, Michael, our government will never become a tyrannical authoritarian government. If you believe that, or if you believe that this country could never fall into the depths of an authoritarian government, you're not paying attention to what's going on around you. So to the woman up in Boulder, with her 3 billboards, you're a liar. Take down the lies. You know, one of the things that I do that you don't have to do is I watch different cable news shows, and then, of course, when I'm doing show prep or the podcast prep, I dig around through my clipping service and my news services to find stories that I think personify just how out of touch the media is living in their East Coast and West Coast bubbles. Well, Joe Scarborough, and as I've said before, Joe Scarborough, I've known Joe since he was a U.S. congressman, before he became a talking head on MSNBC. Joe represented a congressional district in the Florida Panhandle. And when I knew Joe, he was this level-headed, reasonable guy that really tried to understand, the implications of policy. He was what I would consider to be a legitimate, true conservative, an individual that loved liberty. So I don't know I do know what's happened to him. Joe became a pundit on MSNBC, and they truly do live in a bubble. I don't know how many of you ever get to New York City, but New York City is really a small town. I know it's got 10, 12 million people. I don't know what the current population of New York is, but it's a small town in this sense. Everybody in the media knows everybody else in the media, and that's their circle of influence. Those are the people that they hang around with. So they live in this small echo chamber in the midst of one of the largest cities in the world. And that echo chamber that they live in causes them to lose any sense of reality. Here's the example I want you to hear. He's talking to John Meacham, and they're talking about Donald Trump and the Mueller report, and they're talking about Trump's reaction to the Mueller report.
John Meacham, it's almost as if they are reading talking points sent out by somebody saying
they would never do that on Fox News.
An innocent man does not screech and complain and whine all weekend. So it's almost as if somebody got to all of them and said, you need to start saying the president's happy.
An innocent man does not screech?
John Meacham, it's almost as if they are reading talking points sent out by somebody saying
they would never do that on Fox News.
An innocent man does not screech and complain and
actually, Joe, you are entirely wrong about that. The innocent man is probably the one who screeches and complains the loudest. I know that if I were falsely accused of a crime, if I was falsely accused of some sort of wrongdoing, I would be screeching and proclaiming my innocence from the mountaintop with the loudest voice that I could find. I would be doing everything to prove my innocence. This is the world that they live in. I want you to think about yourself for a moment. If you were falsely accused of a crime, you were falsely accused of a sexual assault, you were falsely accused of committing a murder or of manslaughter, you were falsely accused of embezzling, of doing just pick whatever crime you can think of off the top of your head. If you were falsely accused of that, would you just sit back and say, well, I've been accused of this, I guess I better find a lawyer and I better get to proving my innocence? I don't think anybody would have. I don't think any rational human would have that reaction. The reaction would be to do everything. And in fact, in my case, I'm sure my lawyer would be trying to rein me in because I've got a microphone. I've got the ability to reach thousands and thousands of people. And if I was falsely accused of something, I would be using every opportunity I have to make sure that everybody that I know knows that I am innocent. I would be, to put it in Joe Scarborough's terms, I would be screeching at the top of my voice. This is how out of touch the media is. I don't know what's happened to Joe Scarborough, but I heard that clip and I wanted to share it with you because I wanted you to think about how you would react if you were falsely accused. I guess they think, because they've already convicted Donald Trump of every crime imaginable. And so when Donald Trump proclaims his innocence, either on Twitter or in a press conference or as he walks out the South Lawn to Marine One, and he tells the reporters, it's fake news and it was a witch hunt and all these other things, isn't that what you and I would do? If we were being subjected to the kind of scrutiny that Donald Trump was being subjected to, I think we would be screeching, to use Joe Scarborough's words, we would be screeching about our innocence. But I thought that was a great example of just how out of touch with reality. It is truly an inverted view of reality. Because when I heard that, I honestly thought to myself, right off the top of my head, that's exactly wrong. I would be doing exactly what Donald Trump is doing. I would be screeching at the top of my voice about my innocence. So the next time you hear somebody in the media say something that is outrageous like that, I want you to realize that I believe it is because they live in this bubble that is a reality that you and I have no connection with. And conversely, they have no connection with the reality of the world that you and I live in. That's why I believe if you're going to listen to the media, you've got to be a discerning consumer of that news. You've got to take it with a grain of salt and understand that they live in a bubble that is totally diverse from reality. I've got to talk about Kate Smith. Those of you who have listened to me, I think it's probably been a tradition for at least 8 years or longer on radio. I would conclude every Friday's show by playing Kate Smith's God Bless America. And I've done that because after 9/11, I was listening to a radio program. I was traveling somewhere, and so I had the radio on. And this individual, at the end of his monologue, at the end of his program, without any introduction or anything else, just played Kate Smith singing God Bless America. And it brought me to tears. It was a very intense time. Obviously, after 9/11, we don't know what's going on. We don't know what's happening. So everybody is on pins and needles. And so you're stressed out. And when I heard that rendition of her singing God Bless America, I had tears running down my eyes. I freely admit it. I'm not crying today. I'm angry today. We were told when Barack Obama was elected, we were told by Michelle Obama. Well, first we were told by Barack Obama that there needed to be we were on the verge of a fundamental transformation of America as we knew it. And I found those words troubling. But I didn't realize how troubling they were until Michelle Obama made the comment about we were going to have to change our way of thinking. We were going to have to change our traditions. We were going to have to change or rewrite our history. And I was absolutely shocked by that statement because a country's traditions, a country's history is what makes that country. Warts, pimples, and all, the good and the bad. When you look at your life, when you look at your family life, we all have, the proverbial black sheep in our family. But that's a part of who we are. We know it, we accept it, we learn from it, and we move on. What's the purpose of obliterating history? If you don't know history, and if you don't know where you came from, and I mean that in the collective, I hate to use the word collective, but I mean it in the collective. If we don't know where this country came from, the good and the bad, then we are, in Orwellian terms, we are very, we are very easily subjected to a new history, a false history. And we can be led down a path that we never thought we would be led down, a path to socialism, a path to communism, a path to a collectivist society where the government reigns supreme instead of the individual reigning supreme. That's why when I see the burning of books, the banning of books, the banning of speech, hate crimes, when I see the destruction of Confederate soldiers, Confederate heroes, when I see the painting over the covering of white heroes, Kate Smith, it doesn't make any difference whether it's black or white. It doesn't make any difference whether it's male or female. It doesn't make any difference whether it's a good part of our history or a bad part of our history. We should be utterly frightened and object to the rejection and the obliteration of our history. I think what moved me the most about Kate Smith's God Bless America was the song's simple prayer for divine guidance. It was a useful recognition that human judgment taken alone is really an unreliable compass, inherently limited by the passions and the conceits of the moment that we live in. Such doubts, it seems, no longer inform the political culture. Everybody who appoints themselves the arbiter of such things have declared with certitude that Kate Smith's patriotic legacy must be banished because she obliged the petty racism of the day. They appear undaunted by the arguments that Kate Smith was actually a much more complex figure. She did a song, That's Why Darkies Were Born. It was a satire piece on prejudice. Paul Robeson, the civil rights activist, the son of a slave owner, the son of a slave, recorded his own version of That's Why Darkies Were Born. But I don't think that's why they really want to get rid of God Bless America. I think they want to get rid of God Bless America because it is a divine prayer. CNN had a discussion about it with a reporter from the LA Times. And, well, just take a listen.
About this controversy. Joining me, LZ Granderson, ESPN host and sports and culture columnist for the LA Times, and Lou Scheinfeld, former vice president for the Philadelphia Flyers, currently the president of the Museum of Sports. And Lou, it was you who introduced the Kate Smith God Bless America to the Flyers. And for people who aren't sports fans, this was a giant deal for the entire 70s with Kate Smith in person and then the song being played ever since then. And since the removal of the statue and the banning of the song, you say this is the PC police striking again. What do you mean?
Before you hear his answer, do you realize they just admitted that we're banning a song, we're covering a statue, we're doing all the kinds of things that a authoritarian government, now obviously this is not the government doing it, but there's a parallel. It is an authoritarian government that tries to destroy the history so that they can take control of the people. The PC police, the political correctness crowd, is doing that. They are the useful idiots of today.
Well, I think there might have been a little bit of patience, maybe some public discourse. For the Yankees to say, while they're investigating it, they've yanked the song. For the Flyers to ban the song. And by the way, the song pretty much had played itself out. It was 50 years ago in December 11th, 1969 when I first played it. And it's rarely been played in recent years. And it was time to put the song to bed. But to cover the statue with black tarp and rope, and then you have it removed under cover of darkness or in the wee hours when nobody was around. To me, I think that was a little over the top.
Over the top? I think over the top is putting it mildly. But I want you to hear from the LA Times reporter. He's an ESPN commentator. I want you to hear what he has to say about this.
Well, I mean, he's entitled to his opinion, but what's not an opinion is whether or not the content and not just the songs that she is quoted as singing, but also the fact that she performed in blackface at some point and performing as a black mammy. Those things aren't opinions. Those are facts. And the reality is that just as we no longer celebrate the men who used to kill people who thought the earth was round because they believed it was flat, we moved on.
Wait a minute. Have they really moved on? Now, I don't know and I just full disclosure here. I have not researched to see whether or not Kate Smith ever appeared in blackface. It wouldn't surprise me if she did, because we're talking about the 1930s. You cannot judge history through today's lenses. You can only judge history by what was occurring at that time. But let's assume for a moment that Kate Smith appeared in blackface. Don't you find it deliciously ironic that this Los Angeles Times reporter is all upset that sometime in the 1930s Kate Smith may have appeared in blackface, yet we still have Ralph Northam, the governor of Virginia, who admittedly appeared in blackface and is still in office? Where is the outcry for him to leave office? You notice suddenly there is no discussion about that whatsoever. Back to the reporter.
We've gotten better as a society, and this is just one more step in us becoming better as a society.
You know, Lou, you wrote an op-ed, and in that op-ed you said what's caused the ruckus are songs she recorded in the 1930s that today are considered racist. Aren't they just flat out racist? Can't we just say that the song she recorded and the language she used then is just racist, Lou?
Before we hear what Lou has to say, remember the song that they're talking about, the song That's Why Darkies Were Born, was meant to be satire. I've always found it interesting that people who are either intellectually dishonest or intellectually impaired to a certain extent are unable to understand either sarcasm or satire. And in this case, when you have the song, That's Why Darkies Were Born, that was actually recorded by a civil rights activist, Paul Robeson, this shows me the kind of historical ignorance that you have anytime you listen to the media.
Absolutely. The language is repulsive to me and to everyone else today, with anybody of a decent mind.
Wait a minute. I've got a decent mind, but I understand the historical context, and I also understand that it was satire. My gosh, people, is satire no longer acceptable?
But that was 80 or 90 years ago, and you have to take certain things in context. You want to go back and rip anybody apart for any transgression they might have done 80 or 90 years ago? Look, it was acceptable then. To me, it should never be acceptable, and I agree with LZ. But are we going to tear everybody down? Francis Scott Key, who wrote the national anthem, was an ardent slave supporter. And what do we do about the national anthem? We can't keep tearing everybody down. It's history. Let's learn from it.
Amen and amen. It's history. Let's learn from it. I'll never quit listening to Kate Smith and God Bless America. So let's go back to the Supreme Court. The Supreme Court heard oral argument on the issue of whether or not the Commerce Department can add a citizenship question to the census. Now, the way these cases get to the Supreme Court is fairly complicated. And the basis upon which the Supreme Court agrees to hear a case is very complicated. The court has to do what's called grant cert for a case to be heard. In the case of the citizenship question, I think the reason the Supreme Court has agreed to hear the case is because different district courts have ruled against the Trump administration, and the administration sought the unusual remedy of direct review by the Supreme Court. So because all of these other courts have used different reasons and come out with different results about whether or not a citizenship question can be added to the census, I think that's the reason the court agreed to hear the case. Also because we're coming up on the census pretty quick, and all of the forms and the procedures and processes and everything that the government has to do to conduct the census, that needs to get started right away. So the court granted direct review of the case, meaning that it didn't have to go to the 10th Circuit Court of Appeals or to the 9th Circuit. It means the court just said, bring those cases up. We're going to hear them now. So they had the oral argument. And the consensus among most media pundits is that the administration is going to win. For example, Adam Liptek at the New York Times wrote, the Supreme Court's conservative majority seemed ready on Tuesday to allow the Trump administration to add a question on citizenship to the 2020 census, which critics say would undermine its accuracy by discouraging both legal and unauthorized immigrants from filling out the forms. It appeared to divide the court along the usual lines, with its 5 conservative members poised to defer to the administration and the court's 4 liberal members ready to question its motives and methods. Time out. I am so tired of having Supreme Court justices divided between the misnomer of conservative and liberal. How about we talk about Supreme Court justices based upon their philosophy of interpreting the Constitution? Those who are textualists, those who read the plain meaning of the language of the Constitution, versus those, the so-called liberal members, who want to make policy, who want to make law as opposed to interpreting law. But I digress. Justice Sotomayor, for example, she took the lead in challenging the administration's proposal. She said that adding the question would do damage to the fundamental purpose of the census, which is to count everyone in the nation. She said, quote, there is no doubt that people will respond less. That has been proven in study after study. If the purpose of the census is to count the people in the country, simply asking whether or not you are a citizen, the question is not whether or not you are here in the country legally or illegally. It's not even whether you have a green card, a tourist visa, or anything else. It's simply asking, when the form comes in the mail to you, the question is simply, are you a citizen or not? That's all. What's so difficult about that question? And you know what? You could ignore the question if you wanted to. Over at Politico, they wrote this. The Supreme Court seemed divided along ideological lines Tuesday as the justices heard arguments. All of the court's 4 liberals sounded highly skeptical about Commerce Secretary Wilbur Ross's decision, which 3 federal judges found illegal because it lacked a coherent explanation and could lead to a large undercount of non-citizens as well as Americans of Hispanic origin. Chief Justice John Roberts seemed to be in the same camp as Gorsuch and Alito, but was somewhat less strident in his questions. Alito said that he was convinced of deep flaws in estimates that adding the question could lead to roughly 5% fewer responses from non-citizens. He said this, I don't think you have to be much of a statistician to wonder about the legitimacy of concluding that there's going to be a 5.1% lower response rate because of this one factor. I guess I have to ask, who cares? All you're asking is, are you a citizen? And if people choose to not answer that question or to not respond to the census, and they do so because they're not citizens, I guess I don't really care. I would kind of like to know how many non-citizens there are in the United States versus citizens. I would like to know that out of curiosity. But the argument that I hear is this, that we need to know the number of people, let's say pick any random congressional district or any state, that we need to know the number of people in that state so that we can apportion congressional districts based on the actual population. Well, wait a minute. Non-citizens should not be voting. So if non-citizens should not be voting, why should they count in the apportionment of congressional districts? I think this whole thing about asking whether you are a citizen or not shows that liberals, progressives, Democrats don't want to ask that question because they don't want people to know how many non-citizens are actually in the United States. Stay tuned. I'll let you know what the decision is. One last topic for the day I want to get to. You may or may not have heard that U.S. Border Patrol agents have found a 3-year-old migrant who was alone in a cornfield at the border between Mexico and Texas on Tuesday morning, according to the Customs and Border Protection officials. The report says that the boy, the 3-year-old, I am astounded by this, and I'm also angered by it. They say the boy was in distress. He was crying when the agents found him in the Rio Grande Valley near Brownsville. He was identified only by a phone number and his name that was written on his shoes. So the agents took the boy to a U.S. border station. They've been attempting to find his parents using the number on his shoes, and so far they've been unsuccessful, and now they're in the process of transferring the boy to the care of Health and Human Services. A 3-year-old, abandoned. That ties in with a new report from the Rand Corporation that found that smugglers and cartels earned as much as $2.3 billion from Central American migrants in 2017. Let's think about that 3-year-old boy and the cartels and the smugglers. Some poor family in Guatemala, Honduras, I don't care, some S-hole country in Central or South America, paid the smugglers or the cartels to get that 3-year-old boy across the border. And then they abandoned him. They took the money and left the 3-year-old. Now you tell me, I am truly so angered by this. When I think about a 3-year-old child left in a cornfield with nothing but a phone number and his name on his shoes, you tell me that we don't have a border crisis. Now let's go back to the Rand Corporation report. It was conducted by the Homeland Security Operational Analysis Center. It's operated by RAND. I've actually used this organization before. They analyzed the black market for human smuggling in Central America, Mexico, and along the U.S. southern border in an attempt to understand how it works and how much money is going to the drug cartels, or, as the government puts it, TCOs. You know what a TCO is? A transnational criminal organization. We might identify the federal government as a transnational criminal organization. So the migrants generally pay the smugglers and the smuggling networks anywhere from $2,000 to $7,000 per person to get to America. Now, a portion of that money ends up in the hands of the drug cartels, even though the cartels don't directly participate in the smuggling. Here's why. Human smugglers and drug traffickers conduct similar activities, providing illicit transportation services across international borders, and they do so along common smuggling corridors, suggesting opportunities for overlapping businesses. However, the researchers found little evidence that drug trafficking cartels engage directly in human smuggling. The drug trafficking cartels, however, control the primary smuggling corridors into the United States, and so they charge the migrants a tax known as a piso to pass through their territories. In addition, drug trafficking cartels also coordinate some of the unlawful migrants' border crossings to divert attention from their other illicit activities, and then they recruit or coerce some of these migrants to carry drugs for them across the border. All of that amounts to about a $2.3 billion profit they make. They made money off this 3-year-old child. They made money from that family that wanted to get that child into the United States. We have got to stop somehow these caravans from either getting into Mexico and certainly from getting into the United States. Otherwise, we're going to start finding the bodies of 3-year-olds in cornfields, and surely nobody wants that. So whether it's a wall, whether it's a barrier, whether it's technology, whether it's more border agents, whether it's somehow convincing Mexico to stop them at the southern border by cutting off aid to Mexico, doing something, we've got to get control. I would encourage you, if you have friends in your circle of influence that think that we ought to have open borders, I want you to tell them about a 3-year-old child found crying and in distress alone in a cornfield with nothing but a phone number that they can't connect anybody to and his name on his shoes. What do you do about that? Shame on us and shame on them.